Sir, I think we should start. A lot of people are joining on YouTube. So I think we can start. I'll be continuing the admission process.
Okay. Uh,
Professor Bharti.
Yes, hello Poonam, how are you?
I'm good. How are you?
I'm fine too, yes. Yeah.
so,
So,
ma'am, uh, can we start?
Yeah, sure, absolutely, yes, yes.
Okay, just Milind.
Yes, sir. So Abhilasha will be giving the introduction.
Okay, sure. Okay, continue, please.
A very cheerful good evening to everyone and all present here. I, Pilasha, with my team Lawletical, welcome you all to the webinar. Today we are gathered here on this virtual platform to know about the topic Rights and Duty Perspective of Environmental Laws in India. The webinar is organized by Lawletical in collaboration with Rameshwarnath Social and Welfare Foundation with Srimati Pratibha ma'am and Dr. Santosh sir as the founder. We welcome you ma'am and sir. Also, on the behalf of Lawletical, I would like to welcome Dr. Poonam Verma, ma'am. Welcome, ma'am. Lawletical is a community of young minds. We do commentaries on latest legal developments, provide you insights on what's happening in the legal and technical sphere through blogging. Before beginning with the session, I would like to welcome and introduce and our guest speaker, Dr. Bharti, who is a professor of law at NLU Delhi. She has a long experience of teaching law since 1998. She has published several articles and paper presentations on various topics of law. Ma'am is also involved as faculty coordinator for legal aid activities at NLU Delhi. She has taught across a wide range of subjects. Her areas of interest are constitutional law, environmental law, family law, and criminology. She has done her PhD in alternative dispute resolutions with emphasis on Lok Adalats in Delhi. Today, we are extremely privileged and thankful to ma'am to have you among us and for the precious time you have given us. Now, I'd like to invite ma'am to enlighten us with the views. Over to you, ma'am.
Thank you so much, Abhilasha, and I'm extremely grateful to Lawletical. How do you pronounce it? Lawletical, yeah. So Lawletical, the organizing and the associated affiliates, and especially to Dr. Santosh and Dr. Poonam Verma. My topic for today to speak on is the rights and duties perspective of the environmental laws in India. So essentially, when we're looking at this, I would proceed from the generic to the particular, from the general to the particular. So essentially, we would look at a slight background of rights and duties per se as a legal concept. Essentially, right is an entitlement, it is a permitted sphere of action. It is really a creature of law which is armed with legal sanction and it is enforceable in a court of law. So it is enforceable by judiciary. And of course, it is to be distinguished by moral right, which cannot be enforced. So very simple example is a moral right of an employee not to be harassed, and you have a particular law which is on sexual harassment, prevention of sexual harassment. So these are the two kind of the kind of dimensions of a right, which is legal and moral. Then rights can in turn be fundamental rights and human rights. And we are aware that in the Constitution also, we have a whole chapter fundamental rights, which really pick up on the human rights conspectus. These are rights which pertain to every human being across, on a global scale. And these are rights merely, they are recognized and they are enforceable through the auspices of the High Court and the Supreme Court. So these are not rights that are invented or they are given. They are rather simply merely recognized, they are existing. And human rights are really the universal set of rights, which irrespective of nations, and they are not country specific, and so they apply across to all nations. So this is a kind of a slight, of course, we are aware of jural postulates also, which is in the Hofelden scheme of things, which relates to jural opposites and the jural, correlatives. So in case of jural opposites, we have a situation of right and no right. and in the case of jural correlative, it is a situation of right versus duty, right? So this is the kind of scenario as far as the rights are concerned on a very general scheme of things. When we come to the duty, the scenario relating to duty, we find that duties is basically an obligation, and it relates to the moral. It can also be in the moral sphere and in the legal sphere. So a duty can be, not to hurt another's feelings. That would be a moral duty, and a legal duty, a pertaining, having its source in that would be the law of defamation. So, and with respect to both rights and duties, you have relative, you have the situation of absolute rights. For instance, you have in the ICCPR non-derogable rights relating to right against torture, and you have qualified rights, as we're aware that none of the rights are really absolute. There are reasonable restrictions on them in the Indian Constitution as are given. Again, for duties, you have the concept of absolute duty and relative duty, and this is under the Austinian scheme understanding, and where an absolute duty may be owed to the state, and a relative duty is owed to an individual. But Samant refutes this, and according to him, there is no concept of absolute duty. A duty has to have a corresponding right. Right, so this is a kind of background. So duty is basically in order to ensure peaceful coexistence, and duties are owed both to state and to individuals. You find that a duty essentially is generally, in the Indian system, the fundamental duties are they are cited in Article 51A, and they are non-enforceable in the main. But, through the various interpretations, various progressive interpretations of the court, we find that even in the scheme of duties, a duty, the chapter on duties, it relates to individuals. And the courts have interpreted that duties to individuals, these really on a collective sphere, they imply duty of the state itself. Further on, you find that even when the state is to apply a fundamental right, it would consider the observance of fundamental duties. So fundamental rights are not to be considered in isolation, and a person who is looking at a vindication of in case of a violation of a right, his performance of duties would also be considered. There is also, you would find that so the patent violation by an individual of a particular duty may have a very important role to play in the for the purpose of a remedy in case of violation of a right. So there are these various aspects that have to be kept in mind. It is also considered that duty is it is a contribution of the Eastern jurisprudence, and Mahatma Gandhi, Lokmanya Tilak, these were all the forebearers. They emphasized a lot upon the concept of duty, and it was considered part of the dharma in the ancient Indian traditions. While the concept of rights is a more Western, it has more of a Western jurisprudence in origin. So this is a kind of a background which I wanted to give you as at the immediate start. And when we are looking at the Indian Constitution in particular now, we find that it is a social document, as we all realize, and it is a transformative document. And due to this, the whole chapter on fundamental rights is of paramount importance. It is the central feature of the Indian Constitution, and you find that the whole idea of incorporating rights has really lifted the Indian Constitution at a different pedestal. The Indian Constitution is a very, we sometimes call it as a patchwork of different provisions in different constitutions. Fundamental rights was not part of the Government of India Act of 1935, primarily the model on which the Indian Constitution is based. But of course, the French understanding of rights and the American Bill of Rights, these were the basic ways in which the Indian Constitution borrowed this concept. And we find that essentially the dignity and the equality of the individual is absolutely significant in this chapter of fundamental rights. And this elevates the individual, and it is so all individuals have to be treated at par, and this idea of rights is so central and so fundamental that anything besides this, when we talk about duties, it is actually at a subsequent level. So it is only when you're able to fulfill all the the various dimensions of rights which are included in the fundamental rights chapter, and because it is meant for the protection of the vulnerable, for the marginalized, of the people who are affected and afflicted. So essentially, the rights chapter, the rights-based narrative, is a very important component of the constitutional scheme of things. And it was part of the original constitution, as we are aware of. The fundamental duties has come up much later, in the form of the 42nd Amendment Act in 1976, when it was incorporated after the Swaran Singh Committee gave its recommendations based on, the Universal Declaration of Human Rights, Article 29, and also the Soviet Constitution. So taking inspiration from that, we find that the fundamental duties were incorporated. So by themselves, it is not to say that the fundamental duties have no significance. They are part and parcel of the Constitution now. In fact, the lack of enforceability or the lack of, sanction of the kind of duties that are present in the Indian Constitution, it is definitely a norm. It does not impinge. The lack of sanction does not impinge upon the significance of the duties, and it is considered to be at par with, say, the conventions of the Constitution or the various norms of international law, which also need to be observed in the affairs of the states or the affairs of the Constitution, of a particular country, irrespective of the lack of sanction to them. So we are aware that the Indian Constitution, there are several conventions that have come up. A lot many relate to, for instance, the powers of the president, especially when the majority party loses its, the party in governance loses its majority on the floor of the House. So these are conventions which are respected. These are conventions, not that there is a kind of corresponding, compliance that is associated with them. So similarly, it has been compared that when we are looking at duties, even though they lack that kind of practicality to them, that enforceability to them, yet they remain very integral and they are to be observed, right? So because just as we compare it to conventions or we compare it to norms of international law. So this is a kind of, the kind of background that we may look at. And we may then come to the whole issue of environmental rights and duties from the Indian perspective. Again, I would like to go a bit into the general and then come to the specifics of the Indian situation. So when we are looking at environmental rights, now these rights, there are two kinds of ways to look at it. There is the environmental right to environment and there is the right of environment, right? There are, this is a developing kind of understanding. Right to environment is a environmental right, it's a human right, and you consider it that the right to having a clean, healthy, wholesome, sustainable environment is a precondition to enjoyment of a wide variety of human rights. Say right to health, right to livelihood, right of indigenous communities, right to life itself. So it is sometimes considered as a precondition to the enjoyment of these rights, or sometimes it is considered to be, integral to the for the purpose of the human rights. So this is one way of looking at environmental rights: right to environment, right to having a good, clean environment, so that the human beings may flourish, so the human beings may have a decent civilized existence. This is one way of looking. Now, the second emerging thought, and mind you, this particular way of looking at things is a very anthropocentric view. So, anthropocentric view is wherein individual, the human being, is considered to be at the is the primary species, or the human interest is primary, and all other elements of nature are considered to be subsumed, within the human interest. So it is essentially the human interest which will dictate, the human need will dictate what actions are to be taken in order to ensure that human beings are able to live in a comfortable manner, in a decent manner, right? So it is the human beings themselves that are leading the way, and they are at the prime. They are placed at the prime pedestal. When we are looking at the other kind of rights, which is right of nature, rights of environment. Now, this is an ecocentric view, which looks at all species of environment, which is beyond the human species themselves, which means whether it's plants or animals, rivers, mountains, all these are considered to be at par with each other. So none of the human beings are not considered to be at a greater level, or they are not considered to be at a premium as considered to other elements of nature. So rights of nature or rights of environment. So, just by this very a small differentiation in the kind of preposition which is used, rights to environment and the rights of environment, we see that there is a lot of difference. Now, in the Indian system, the rights of nature have also been recently, there has been a kind of flip or a catalyst given in the form of the Uttarakhand High Court judgment, which in the year 2017-18, it looked at, the rivers in the Uttarakhand region and the forests, the entire ecosystem. It considered it to have a legal standing, that there are rights of nature which need to be protected, which need to be preserved, and for which the local authorities were made the parents patriae. They were made in charge, that they had to look into preserving and protecting these various elements of nature. This is, of course, an idea which has come forward through the Australian and the New Zealand, the indigenous tribes, the kind of the protection of the rivers and the forests there, and it has made its mainstay. It is coming up in a very strong manner in different parts of the world now, including India. But this is a very it's a very slow process, and it is not yet made too much dent, in the entire understanding of environmental laws. Now, when we are looking at the rights to environment and the rights of environment, again, let's keep aside the rights of nature, because this is something which is coming up, slowly, and it is emerging. It is still in its way of evolution. So if we even concentrate on the rights to environment, here also there are two ways of looking at it. One is from the point of view of greening of the human rights entire corpus of treaties. So when we're looking at right to life, we are considering that for the enjoyment of right to life, you consider that right to a good environment is an integral component of right to life. The other way is to have a right to environment in itself as an independent right. So that is something, another another kind of dimension which is emerging, and it has not yet ripened. So it is an independent right, an independent human right to environment is something which is on the anvil. It is something which is being, progressively, it is being taken up, but it has not yet come up as a very major, say, kind of a commitment in terms of the rights treaties, human rights treaties that have come up so far. So far, we find that human rights have basically imbibed, they have integrated the right to environment within its four walls. So the independent right to environment has not come up as a strong measure. It is yet to take place, but certainly its impact is, in a derivative form, is certainly there. You find that the Stockholm Conference of 1972, it gave an entire flip, it gave a huge momentum to the environmental law journey internationally. And the preamble and the principle 1 talked about rights and responsibilities of human beings in relation to environment. So that was really a starting point, a formal starting point for this whole, say, kind of deliberations on the kind of interconnectedness between rights and duties in relation to environment. You find slowly this whole thing has picked up, the whole momentum has picked up, and now many national constitutions, including that of India, and India itself was inspired by the Stockholm Conference, whence it integrated the fundamental duties in relation to environment also as part of the mini constitution, the 42nd Amendment Act that came up in 1976. The concept of sustainable development, which all of you, as all of us, as students of law, we are the SDG goals that have come up in 2015, the Paris Agreement that has come up in 2015, and the understanding of sustainable development itself that originated in the Brundtland Commission report of 1987, and thereafter it found its way in the Rio Conference of 1992, in the Agenda 21 of the conference, an important document that emerged from it, the United Nations Framework Convention on Climate Change, the Convention on Biodiversity. These were all major documents that came up through the Rio Conference of 1992, and the central tenet was sustainable development. So sustainable development is understood as integrating the conflicting objectives of development and environment. And interestingly, why we're talking about sustainable development is because later on a little bit, you find that in Johannesburg Summit of 2002, a third element, which is the social dimension, was added to the understanding of sustainable development. And the social dimension was sometimes reinterpreted to mean human rights. So human rights, the economic development, and the environment. These were three pillars or components of sustainable development, and they became a very important, part of the agenda of different nations, how to proceed in terms of futuristic possibilities. You find that, of course, apart from these, there have been a number of multilateral environmental agreements, and the most important being the climate change agreement that has come up in such a significant manner in 2015, wherein all the nations of the world have pledged through their nationally determined contributions to contribute their might to reduce carbon emissions through voluntary kind of commitments that they would undertake, and every 5 years there would be a progressive, there would be a progressive scaling of these various objectives. So this is in brief the kind of situation as we are aware of in terms of the international say kind of background to the rights and the duty phenomena, and how, because the international developments has certainly provided a trigger for the environmental development within our country. And we've seen how the Stockholm Conference, it became the main reason for, having Article 48A and 51AG. And apart from these, you find that there were certain entries in the 7th schedule that were amended in 1976. So you have entry 17A, 17B, in which forests and wildlife protection, they were incorporated in the concurrent list. Then you also find that 11th schedule was added by the 73rd Amendment Act in 1993. The 12th schedule was added by 74th Amendment Act in 1993. These related to local self-governments in terms of panchayats and municipalities. And these local self-governments in turn had many environmental functions to undertake. For instance, social forestry, for instance, water management, soil conservation practices in terms of for the purposes of panchayats. And for the urban settings, there would be water and soil and, air pollution to take care of. So these were, we would be aware that Ministry of Environment and Forest was set up in 1980. And of course, there have been a whole spate of laws that have come up in the Indian context, which have contributed so much more. And it's very interesting to note the kind of paradigm shifts that have taken place. So one of the earliest species of law that came up was the Water Act. If you see the kind of the heading of the act, it says Prevention and Control of Pollution Act of 1974. Then in terms for the purpose of Air Act also we have Prevention and Control of Pollution Act of 1981. So it was basically related to pollution control and its prevention. The Environment Protection Act of 1986 was the umbrella act, and which was multifold, and it was much wider in its perspective. It entailed the central government to take any action and all measures for the purpose of environmental protection. It's called the Environment Protection Act. So it's a step ahead of pollution. It is, it's wider in its kind of ambit. And of course, there is a Wildlife Protection Act of 1972, the Indian Forest Act 1927 that continues. It's a colonial piece of legislation that gave rise to various categorization of forests, reserve forests, the protected forests, and village forests. And this kind of classification was basically to enable the imperialists, the British government, to exploit, the Indian forest resources to their end, and to alienate at the same time the tribal communities, because under the new Forest Act of 1927, what was required was that the tribals or whoever might have a claim within the forest, they were required to project it, to make a claim actively, and then it would be resolved through the various agencies. So it was immediately there was an alienation of the tribal communities, and for the centuries, the kind of integrity that was there of tribals and forests, that was sought to be severed through that legislation. Interestingly, 1927, the Forest Act continued post-independence, and the situation did not change, because the only situation change was that now forest resources were using internally for the purposes of development within the country. The major change came up in 1980, Forest Conservation Act, in which any kind of changeover from the forest to a non-forest purpose would require the sanction of the central government. The 1988 new forest policy, which came up, that became a very a change. It set a change, because for the first time, the tribals were recognized to be an inalienable component of forest life. So it took so many years, from 1927 to 1988, this whole vast expanse of time, continued with tribals and indigenous communities being treated almost at the periphery. 1988 was the first significant change, and then, of course, it was followed up by the Forest Rights Act of 2006, where the historical injustice which was meted out to the tribal communities was said to be rectified by granting them various rights within forests. And the Gram Sabha was considered to be a very basic unit, which would require, whose consent was required, for any purpose, any developmental purpose also that needed to be undertaken. So this was a kind of the kind of legislations and the pronouncements that came about. There were, of course, many cases. Now here the rights, the whole understanding of the fundamental rights in relation to environment becomes very, very striking. The public interest litigation that was taken up in a very active manner, the judicial activism that came up in the 90s, 80s, and 90s, it affected all branches of governance, all branches of the kind of issues that came up, and environmental issues were at the foremost, where considerable environmental jurisprudence was built up due to the very, very progressive interpretations of the Indian courts, the apex court, the Supreme Court, and the High Courts. And the Supreme Court under Article 32 and the High Courts under Article 226, they took many actions, suo moto actions, as well as on the petitions of various individuals who were public-spirited individuals, and not necessarily the aggrieved party. So there was considerable relaxation of the locus standi rule. So various principles of the kind of law which usually pertain in case of the usual cases, they were relaxed. The whole idea of res judicata, laches. So all these concepts were called into modification when pursuing the case through the PIL route. And a lot of innovativeness came up by the Supreme Court. So this falls in the fundamental rights chapter, as we're aware, Article 32. So all the cases that came up through the route of PIL, they're actually the vindication of rights in different situations of individuals, those rights that were violated, and they were attempted to be set right by the Supreme Court. The Subhash Kumar versus State of Bihar case, 1991, is one of the first cases where an explicit recognition of the right to environment was made by the Supreme Court. Interestingly, in that case, the right to environment, this precept was not applied because the facts of the case were such where it was a case where the petitioner was shown to be a vested party. So the public interest litigation cannot serve private interests. It can only be meant for public interest. That was emphasized, but nonetheless, the court did find an opportunity to dwell upon this important idea that right to environment is part of right to life. So it is very much now established to be a component of right to life under the Indian law. And an early case in 1985, perhaps, this was the Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh, which is famously known as the limestone quarrying case, the Mussoorie limestone quarrying case, in which it was one of the first cases where the Supreme Court looked at this whole tussle between environment and development and resolved that, yes, these limestone quarrying is important for the purposes of development of the country and so on, but it was spoiling the local fragile ecosystems of the mountainous region of Mussoorie. So various committees were set up, and after the reports that came up, it was resolved that these quarries would be stopped, would be shut up in the Mussoorie, within the city itself, and outside there was a category of there was a categorization which was made of these quarrying units, and some of them might be allowed because they were not affecting the environment, and some others would be closed, right? So it was one of the earlier cases. You have even earlier to this the Ratlam municipality versus Vardichan case 1980, where section 133 of Criminal Procedure Code came up very strongly, and Justice Krishna Iyer, Justice Krishna Iyer and Justice Bhagwati have been the biggest, they have been the foremost propounders of the whole idea of legal aid and PIL in the country. So in Ratlam case, you find that a very, very important section 133 CRPC, which gives the power to the magistrate to remove a public nuisance. This was considered to be absolutely apt in the given circumstances where the municipality had not performed its duty, citing lack of financial resources, and there was a lot of unhygienic problems that were prevailing in that municipality. But the court and the highest court, it emphasized that lack of resources is not an excuse. You cannot cite it as an excuse. It's a matter of life of the people. So you find that this was, then apart from this, you find that oleum gas leakage case is another very important case, MC Mehta versus Union of India, where the principle of absolute liability was highlighted. It was considered to be a modification of Rylance versus Fletcher rule, where the principle of strict liability was now considered to have no exemption or exception, and so it would be converted into absolute liability, and any person who brought any hazardous or dangerous, conducted any hazardous or dangerous activity would be liable absolutely for the harm which is caused. And this case came up just around the time the Bhopal gas disaster case occurred. And it was essentially in view of the Bhopal gas disaster that the oleum gas leakage case, the court was very much concerned, and it wanted to bring out this principle of law, which would have its role to play in the Bhopal gas disaster. But the outplay of events, as we understand, that initially the case went to the American courts, the district court. From there, it was referred to the Indian courts on the ground of forum non-convenience. And then it was initiated in the district court at Bhopal, wherein an interim compensation was given. Thereafter, it reached the High Court, where the interim amount was reduced but maintained. And the judge in the High Court of Madhya Pradesh, he adopted rather the principle of absolute liability in the given circumstances of the Bhopal gas disaster. Unfortunately, when the case came up before the Supreme Court, this whole issue was undertaken in a very different manner, and it was a basic settlement of 470. So it was a settlement of $470 million that was achieved, and this whole rationalization in terms of the absolute liability principle and the deep pocket theory, which was advanced by the High Court in the Bhopal gas disaster case, promulgated initially by the oleum gas leakage case. This was eclipsed in a way. So the seriousness of the situation that came up in the Bhopal gas disaster, it really was sought to be circumvented, and the settlement came as a big shocker, because the settlement did not really, in fact, when you look out at the various terms, it was considered by the judges that it was needed to immediately apply to the victims. They could not have waited for the entire process of the legal proceedings to complete, and there was a need to immediately assuage and to give assistance to the victims. So that was the reason. Of course, they also closed the civil and criminal liabilities that end. Later in 1991, the criminal liabilities were reopened. Interestingly, in 2004, there was a petition that came up in relation to Bhopal gas disaster for environmental remediation. So environmental remediation, which was kind of a lost cause, it did not really, there was no, there was no application of the mind to it, when the case occurred. It was the immediate need was the human suffering that was taking place, and there was a need to have immediate, recourse to the finances in order for the treatment and for the assistance. But later on in 2003-04, the environmental aspect was also highlighted, although nothing has really come out of it. So these are various cases. Now you would find that in the Indian system, I was looking at the whole. We are talking about the role of the judiciary, how the rights, the fundamental rights chapter has been made a reality. In the sense of obtaining environmental justice, and the judiciary, apart from enabling individuals as MC Mehta to come up with various issues before the court, apart from enunciating the very, very important principle of absolute liability, you find other ways also the judiciary has contributed. For instance, in the T.N. Godvarman case, which is again a very, very famous case pertaining to forest issues, the court, this was around 1995, where the whole issue came up in relation to cutting of trees and the using of timber for various exploitative purposes. So the issue came up first in relation to one part of the country, but later on, different parts of the country, wherever the issue of forest governance, wherever the issue of cutting of trees and logging and timber factories, wherever these problems came up, they were all put together under the Godvarman case. And this case was prolonged for over 2 decades through the principle of continuing mandamus. So the court invented this whole process, the way to monitor compliance. Usually we understand that the role of the court is to, to interpret the law to the particular facts of the case. But the court went beyond, and in fact, it has been accused sometimes that the Supreme Courts have been encroaching upon the territory of executive very often. But the problem is, that the Supreme Court has usually found that its orders are in contempt, and it wanted to ensure that its orders relating to forest issues, they are observed in totality. So it set up various committees and so on to look into the observance of these orders. So this is like a very interesting role that the court has played. And it has also, the Supreme Court has also in a Vellore case, which is very striking, and another case is Bichri case, where the polluter pays principle, where the precautionary principle, which are environmental law principles, and these have attained the customary status also, the customary rule status. These have been applied in the Indian situation, right? So the Indian Supreme Court has gone several steps forward to integrate these as part of the law of the land. And now the NGT Act, of course, has, there is a particular provision in the NGT Act of 2010 in which we find that the polluter pays principle and the precautionary principle, they have come up as, and sustainable development principles are the principles that the NGT must also relate to when looking at various cases before it. So actively, it has now become part of, it is a provision of the statutory enactment. So the Indian courts have played the Supreme Court has specially played a magnificent role, in terms of the whole the enactment of the fundamental rights in relation to environment. So the duties is the fundamental duty in relation to environment is cited in Article 51 AG, and it is a very definitive aspect of every citizen. So we know fundamental duties relate to citizens of the country. And so every citizen has to take all steps to ensure, is obliged. So there is an obligation that has been put, on every citizen of the country in order to ensure that the wildlife and the forests and the nature and environment, it is protected, it is preserved. So there is, of course, no formal sanctity to it, which means that the enactment or the enforceability of fundamental duties in general is lacking. But as I said, that there have been various ways in which it has been ensured that even the fundamental duties are duly respected. They should be considered to be a normal feature of our daily lives, right? So when we are, say, throwing the kind of waste, it has to be in the dustbins. It's a small, the smallest of examples. So if we are, and when you're looking even at dustbins, there is to be segregation of waste. So the wet waste has to be kept in one kind of dustbin and the other biomedical waste. So there are all these different aspects of daily life, which make it absolutely so it is a very integral part of our daily lives, that when we look at duties. And I guess I was asked to complete this whole lecture in 45-50 minutes, so I'll just end here because I can go on and on. It's I would like right now, in case you have any questions on whatever I've spoken so far, so it's welcome. Any questions if you have, they're welcome, please.
Participants, if you have any questions, you can ask. Participants, if you have any questions, any doubts, you can ask, you can discuss with the ma'am. Right now, session is open for interaction. Ma'am, I think no questions by the participant side. So I'd like to invite Dr. Poonam Verma ma'am. Ma'am, please give a vote of thanks to Professor Bharti ma'am. Dr. Poonam Verma ma'am, please.
Thank you, Dr. Santosh. Good evening and warm welcome to our most valued guest, Professor Bharti, National Law University, Delhi, and lovely participants. It's my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this webinar happen. On behalf of Dr. Akhilesh Tiwari, Chairman, Dr. G.P. Law College, Prayagraj, Dr. Prabhat Kumar Dikshit, Assistant Professor, HSM Degree College, Hardoi, Pratibha Ji, Treasurer, RSW Foundation and Assistant Professor, Arunachal University of Studies, Arunachal Pradesh. First of all, I extend my sincere thanks to Almighty God. With His blessings and grace, we are able to make this webinar what it was. I extend a really hearty vote of thanks and gratitude to our guest speaker, Professor Bharti, who spared time from her busy schedule to grace the occasion. Today, we had an opportunity to hear your thoughts on rights and duty perspective of environmental laws in India. Your thoughts have enlightened our minds and encouraged us. I would like to thank Dr. Santosh Kumar Tiwari, Assistant Professor, School of Law, Justice and Governance, GBU, and Law Litical for their kind support. I would also like to thank Milan. Are you there, Milan?
Yes, ma'am. Yes, ma'am.
Milind, Abhilasha, Gargi for helping us webcast of a webinar.
Thank you, ma'am.
Last but not least, I would like to thank all the participants, senior professors, teachers, and the legal fraternity present here for attending and giving their valuable time. Thank you very much. Thank you and have a great day. Thank you, Professor Bharti, once again.
I would like, yeah, I would like to take this opportunity to thank you so much for having me here. It was absolutely delightful, and Dr. Santosh and Dr. Poonam. And if there are any questions, because I was looking forward to some questions, from your end. So, in case there are questions, you can forward me or on the email or in any other way. Or should we wait for 2 minutes, as you say?
Ma'am,
Sure, ma'am. Sure.
meanwhile, we also have a memento for you. So, can we present it?
Yeah, Milind.
Sure. Thank you, Milind. Thank you, Milind, for your presence also. Yes.
Yes, ma'am.
Sure.
Abhilasha, can you do the honors, please?
Thank you so much. Thank you.
A big round of applause. Okay, thank you, Milind.
Thank you.
Thank you, Professor.
That's lovely.
Once again. I
Thank
spoke
you,
only
dear.
once and you said yes to me. I'm grateful.
Thank you. It was great to be
Yes,
here. All the best for your future endeavors. All the best.
Thank you very
Thank you.
much.
Dear Milind, just announce about the certificate of the all participants.
Yeah.
Milind ji, just announce regarding the
right
particip.
after, yes, sir. So right after your this meeting gets over, everyone who has participated will be getting an e-certificate. So please send me the details, and I'll share you the feedback link in a day or two, because it is under process right now. Okay. Thank you so much for joining. So let's conclude it. And thank you, Poonam ma'am. Thank you, Santosh sir. Thank you, Bharti ma'am. Thanks everyone for joining. And we can conclude the meeting now. Thank you everyone for joining again.
मैम ग्रुप में कुछ सीनियर्स लोग हैं और कुछ हमारे अभिन्न मित्र लोग हैं